Tambula Vinaka, everyone. Warm Pacific greetings. I don't know if you can see my video. Unfortunately, I feel like there's a tech issue that has just happened with my video. But if you can hear me, please just some of you put your thumbs up. Okay, you can hear me. So um, welcome everyone to those who have joined. As I'm from the Pacific, out of respect, I would like to just ground this a little. When we gather, we begin by acknowledging the oceans that connect us, the lands that sustain us, and the communities that guide us. We gather not just as individuals, but as part of a collective story, one that carries the voices of those who walked before us and the hopes of future generations. There's a proverb that says that we do not inherit the earth from our ancestors, rather, we borrow it from our children. This wisdom reminds us that stewardship is not simply a responsibility, it is a promise. A promise that the choices we make today must protect the future of those who will come after us, the very cornerstone that was used for this advisory opinion. On that note, I warmly welcome you all to session one of our public webinar series, hosted by Pacific Island Students Fighting Climate Change. We are truly grateful that you have chosen to join us for this important conversation. Today's session, from legal principle to action, the ICJ Advisory Opinion and the UNGA resolution, comes at a very pivotal moment in the global pursuit for climate justice. For many communities across the world, climate change is not a distant threat or an abstract policy debate. It is a daily reality, affecting our homes, our cultures, our food systems, and our very connection to land and sea. Yet, despite contributing the least to the climate crisis, the most climate vulnerable people continue to stand at the forefront of the fight for climate justice. Recently, the International Court of Justice delivered a very historic advisory opinion on the obligations of states in relation to climate change. This moment marked a powerful step forward not only for international law, but for communities around the world seeking accountability and protection. Building on this milestone, a new UNGA resolution led by Vanuatu and a dedicated core group of countries now seeks to translate this legal recognition into meaningful action across the UN system. This webinar will explore what that means in practice. How can this resolution strengthen implementation and accountability? How can it help ensure that the court's ruling does not remain only a legal principle, but become a catalyst for real change? To help guide us through this conversation, we are deeply honored to be joined by an exceptional panel of leaders and advocates. First, we have Ms. Leanne Sackett, who is Vanuatu's Special Envoy for Climate Change, whose tireless diplomacy has been instrumental in advancing this movement on the global stage. We are also joined by Ms. Joy Chaudhry, Senior Attorney at the Center of International Environmental Law, who brings deep legal expertise on international environmental governance and climate accountability. We are privileged to have Professor Elisa Murgera, the United Nations Special Rapporteur on Human Rights and Climate Change, whose work powerfully highlights the vital connection between climate action and the protection of human rights. And finally, we have Mr. Vishal Prasad, who's the Director of Pacific Island Students Fighting Climate Change, a powerful youth voice and one of the driving forces behind this historic campaign. We look forward to an engaging and insightful discussion with all of our speakers today. Thank you once again for being part of this important moment and for standing with those most affected by climate change in the global fight for climate justice. If you have any questions, please type it in the Q&A function and we'll get to it at the end of the session. It is now my lovely pleasure to introduce our first speaker, Ms. Leanne Sackett. She serves as Vanuatu's Special Envoy for Climate Change and has been a key figure in advancing Vanuatu's leadership in the global movement for climate justice. She previously served as the Director of International Legal Affairs for Vanuatu's Climate Justice Program, where she played an instrumental role in supporting the historic campaign that brought climate change before the world's highest court. She's also a member of the Permanent Court of Arbitration, chair of Vanuatu's National Group, and an academic at the University of South Pacific, continuing to shape the next generation of Pacific legal thinkers. Her work reflects the strength and determination of Pacific voices advocating for accountability and justice on the world stage. Leanne, it is a privilege to have you with us today. The Zoom floor is yours.
Thank you very much, Shiva. It's an absolute pleasure to be here today and have the opportunity to share a little bit more about the resolution and the direction that it's heading in, and as well some of the background behind it as we reach this critical stage of releasing the revised draft after a round of, well, 4 rounds of informals on the zero draft so far. So as the draft is still being negotiated, obviously I can't refer to specific details or language that's in the draft, but I can very much speak to it in general terms and share a little bit more about the objectives behind it and why we're driving this at this particular moment in time as well. Um, as many of you are aware, Vanuatu and many other small island developing states and other climate vulnerable states are already living the consequences of climate change. Just last weekend we had a cyclone in Vanuatu, in fact, which was not a particularly strong one this year around. We got lucky, but they are always increasing of stronger nature. Sea level rise is also a big issue, and loss of land, culture, and livelihoods is everyday lived experience now for mostly Vanuatu communities. And so it's really not seen as a future risk for us at this point in time. It's a present reality. And in that present reality, we're also seeing, the global community increasingly speeding towards climate catastrophe, despite our efforts under the UNFCCC and the climate and the Paris and the climate regime generally. And these existing processes have made great progress so far, but the scale and urgency of the crisis requires stronger clarity on states' legal obligations, which is really what drove our initiative to request the advisory opinion, backed or perhaps more accurately phrased as pushed by our inspiring youth from the Pacific Island students fighting climate change. So climate change is really not just a matter of policy, it's a matter of justice and it's a matter of international law. And this was confirmed by the ICJ in its advisory opinion, which was handed down in July last year, as I'm sure many of you are aware if you're joining this webinar. Um, the unanimous opinion from the court delivered on climate justice and its key findings recognize that there's a broad suite of international laws well beyond the climate regime obligations found in other treaties, such as UN clause, as well as the human rights treaties, also those under customary international law. They also recognize that states' obligations in relation to climate change are owed erga omnes, so owed to the community as a whole. And they also confirmed, and this is a really important element for the climate justice component of the advisory opinion, is that the rules of state responsibility apply, meaning that states that are responsible for breaching internationally wrongful acts will have legal consequences that follow on. Their legal consequences will follow on from there. And so now we've reached the stage where we have the opinion, and it is standard practice for the opinion to be brought back to the UN General Assembly for a resolution, especially if the resolution has been requested from the UNGA in the first place. And the purpose of bringing it back to the UNGA is to get the political level endorsement and to also look for ways for it to be operationalized. And there is different practices around this in relation to ICJ advisory opinions in UNGA resolutions. So I'd like to share a little bit about some of the core objectives that Vanuatu has been pursuing through the resolution. The first one and the most fundamental objective, and this is the one that can't be compromised on, is a full and unequivocal welcome of the advisory opinion. It's historic in so many ways, from the consensus resolution that was adopted by the UNGA back in 2023 that requested the advisory opinion to the record levels of participation before the court. It became the biggest court in the history of the ICJ, to the unanimous opinion delivered by the court. It would be, I think, inappropriate to accept anything less than a welcome of the advisory opinion. And I don't think there is any precedence for any unanimous advisory opinions ever being accepted with anything less than a welcome of that opinion. Um, and so in that full and unqualified welcome of the advisory opinion, it's also important that we protect. It's essential to protect the authority of the and the integrity of the not just the advisory opinion, but the court itself. And it's a critical time to be protecting international law and the rules-based order that we all operate under in international relations. And we also need to avoid any dilutions. To achieve this, we need to ensure that there are no dilutions or reinterpretations or minimizations of the findings or its unanimous character in the resolution. So that's objective number one. And there seems to be broad support and broad consensus for this. I wouldn't say consensus, but at least broad support for this objective to be achieved in the resolution. The second objective that we're pursuing is strengthened climate action. The courts provided us with clarification of the legal obligations, not just under the climate treaties, but also under the other areas of international law. And so it's critical that we think about how states can now carry out and ensure that they're fulfilling these obligations since they've been clarified. And so a lot of the operative paragraphs focus on the various areas that the court clarified in its opinion, and tries to seek legal alignment of states' conduct with the obligations clarified in the resolution there. And so various things have been included, of course, obligations on under the climate regimes, but also those that are more broadly under customary international law. I won't go into too many of the elements there unless there are questions around this, because I'm conscious about going over time. But other areas like sea level rise, which is in critical importance for SIDS, as well as the principle of non-refoulement, are also included in there. And then the third objective is advancing climate justice, which has always been at the very heart of this initiative since the very beginning. And we seek to do this through operationalizing the advisory opinions findings in relation to state responsibility and climate harm under international law. And initially, we were quite public and open about this from last year, that we were proposing to establish a register and a register for climate harm, and the idea of a mechanism for climate reparations through this resolution. In the current political context, it's a really tough fight, and so while we saw this architecture or these mechanisms as being a great opportunity for the UN membership to explore, and we are still continuing to explore this, the modalities for establishing them, and perhaps the speed in which they can be established, if established at all, is evolving as we go through the negotiation process. Have I reached my 10-minute mark yet, or is there an opportunity to speak a little bit longer?
You still have a little bit of time.
Fantastic. I think there's a couple of things, since this is being hosted by the Pacific Island students fighting climate change, and there's a youth element here. It would be great to share where the resolution seeks to support, help, or strengthen the protection of present and future generations. And it does this in three different areas. So the advisory opinion, it explicitly recognized the right to a healthy environment essential to the enjoyment of other human rights. And so the right to a healthy environment is very much at the very beginning of the resolution. And we've also proposed in their language in the draft that also recognizes the collective and intergenerational dimensions of this right. At the moment, this is an area that's sensitive for some delegations, and so we're not sure if it will get through into the final version of the draft, but we very much hope that it will. This is definitely a key priority for Vanuatu and many of the other SIDS that are advocating for this resolution. There there are also paragraphs relating to the protection of the environment and its contributions to human well-being and the enjoyment of human rights, specifically for present and future generations. So this has also been included. And finally, within the acknowledgement of or the recognition of the most directly relevant applicable laws as clarified by the court in the advisory opinion, the principle of intergenerational equity is also included in there. So these are the very specific explicit references that support present and future generations. But when looking at the resolution more holistically in the way that we've tried to address climate justice, there are, and its objectives that it's trying to achieve, there are very I think there are many ways in which the resolution aims to pursue climate action and responsibility and also accountability for harm that will be essentially received by not just the present but also future generations. So I may stop there, and I'm assuming my time is up now, but I'm very happy to answer any questions that come up afterwards. Thank you.
I'm on my phone. Hopefully, you guys can see me now. Thank you for your clear overview of where it is currently in terms of the resolution and what the resolution hopes to reflect. The specific and explicit components of the resolution to address climate accountability and responsibility. And I hope the audience can get a better idea for their questions as well. So please do not hesitate to write your questions in the chat and address it to who you want to answer the question, and we will get to that in the question and answer sessions. It is now my pleasure to introduce our next panelist, Ms. Joey Chaudhary, Senior Attorney at the Center of International Environmental Law. Joey brings extensive expertise in international environmental law and human rights and has been one of the lovely voices in advancing legal accountability for the climate crisis. Today, she will help us unpack an important question. What are the most significant legal clarifications emerging from the advisory opinion? And how can the UNGA resolution help embed these principles across the UN system? Put simply, this resolution represents a critical bridge between legal recognition and real global action, ensuring that the court's findings do not remain only on paper, but help guide decisions and accountability across international institutions. Joey, we are delighted to have you with us today. The floor is yours.
Thanks a lot, Shiva. And I'm going to try to, I have a PowerPoint. We'll see if this works. I'm going to try to share. All right. Okay. Can you see the PowerPoint? Yes? All right, great. Yes, so very much building on Leanne's very rich intervention at a moment when climate devastation is accelerating worldwide and climate destructive conduct too often escapes accountability, we recognize the ICJ's climate ruling as historic, and the content of the opinion provides such a sound foundational basis to move beyond vague promises and voluntary pledges and ground much needed climate ambition in legal obligation. In short, we're seeing how this ruling has shifted the legal landscape, putting the weight of international law behind climate action. And the moment that we're now entering, that Leanne spoke about, when the UN General Assembly will vote on a resolution to welcome and operationalize the ICJ-AO, this moment holds immense significance. Why? Because this resolution is such a critical piece of the implementation puzzle. Now, since its delivery in last July, the AO has begun to function as an authoritative legal reference point, providing actors across fora with a shared legal vocabulary for advancing claims of responsibility and accountability. And the resolution process now functions as a political signal from states regarding the ambition with which they are willing to take the court's opinion forward. One critical avenue to put normative clarity of the ICJ, as Shiva mentioned, into practical action. And the resolution, of course, builds on this very powerful foundational basis that the court laid out. So as Shiva mentioned, what were those most important legal clarifications by the ICJ? Leanne already referenced a few of those. I'll go a little bit deeper. I have a few slides with some few key paragraphs from the opinion, but this is by no means an exhaustive selection of all the relevant passages, because I see a lot of ICJ experts in the room, so bear with me. So what were the most important legal clarifications? There's applicable law, as Leanne mentioned. Multiple sources of treaty and customary international law apply. On states' obligation, the court identified binding duties under these multiple sources, ranging from the Charter of the United Nations and the climate treaties to customary international law, international human rights law, law of the sea, among other sources. And the ICJ was clear that the principle of lex specialis does not lead to a general exclusion by the climate change treaties of other rules of international law, and the court was equally clear the law of state responsibility applies in full. Then another very key element, and Leanne touched on this, but it shows the global scope of the opinion, the global scope of responsibility, the erga omnes nature of the obligations. So on the weight of climate duties, the court clarified that obligations to protect the climate system are erga omnes obligations, essentially owed to the international community as a whole. This means that when obligations are breached, this entire range of primary obligations that we just touched on, under customary international law, any state may invoke responsibility for the breach. Under the climate treaties, all treaty parties may likewise do so. And while only injured states may claim reparation, all states have a legal interest in the protection of obligations erga omnes. We also had a powerful clarification from the court that the duty to prevent significant harm to the environment absolutely applies in the context of climate change, with the court identifying a stringent standard of due diligence as a required standard of conduct, making clear the need to adopt and enforce appropriate legislative measures, administrative procedures, and enforcement mechanisms to prevent significant harm to the environment, including the climate system. And then we have the issue of fossil fuel phase out. Now, state obligations in respect of climate change are grounded in the best available science, and the science is clear. Increases in atmospheric greenhouse gases are primarily due to human activities, the largest source being the burning of fossil fuels. It is thus highly relevant that in what is perhaps its most quoted passage, the ICJ explained that the failure of a state to take appropriate action to protect the climate system, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act which is attributable to that state. In this moment of the triple planetary crisis, operationalizing this part of the advisory opinion is essential for meaningful climate action. And then we have, for our COP friends, and I see a number in the room, the content of NDCs. What are NDCs? Nationally determined contributions or countries' national climate action plans under the Paris Agreement. Now, the court had a lot to say on the content of legal standards under the climate treaties, but to zoom in on NDCs, the court rejected a purely process-focused tick box exercise understanding of NDCs, confirming that NDCs must become more demanding over time, must reflect a party's highest possible ambition in alignment with stringent due diligence and the principle of common but differentiated responsibilities and respective capabilities. And the court made clear that countries can no longer claim unfettered discretion because discretion is limited. Then very powerfully, and I know this, at least to me, it's very close to my heart, the court also delivered powerful conclusions on human rights. Leanne also touched on this. It affirmed that climate degradation impairs numerous human rights, including the rights to life, health, food, water, housing, and family life, as well as the rights of women, children, and indigenous peoples, including participation rights. Given the far-reaching recognition of the right to a clean, healthy, and sustainable environment, the court found that it is difficult to see how these obligations can be fulfilled without ensuring the protection of the right to a clean, healthy, and sustainable environment as a human right. Also, for those of us who work on issues of climate-induced displacement, on climate-induced displacement, the court affirmed the relevance of the customary international law principle of non-refoulement. This means that individuals cannot be returned to a country where climate impacts would expose them to irreparable harm to their right to life. And then very, very importantly, because accountability is vital for a climate justice approach, the ICJ was very clear. Loss and damage already endured must be recognized and repaired. This is essential given how loss and damage is manifesting in truly devastating ways all across the world with little redress or repair. In terms of forms of legal consequences, the court affirmed that engaging in climate-destructive conduct in breach of climate obligations may trigger the entire panoply of legal consequences provided for under the law of state responsibility. This is cessation of harmful conduct, assurances of non-repetition, and the provision of full reparation, including restitution, compensation, and satisfaction. What makes this case so important is that it addresses the past, present, and future of climate action. It's not just about future target, it also tackles historical responsibility, critical because we cannot solve the climate crisis without confronting its roots. So the conclusions of the court, and I have not covered these comprehensively, are critical as a foundational clarification of the obligations of states in relation to climate change. Many of these issues for a very long time are open, constantly in debate, and now have been answered. That matters so much. So now to start to conclude, importantly for us to consider in relation to the UNGA resolution, looking to endorse and operationalize the ICJAO, it is important to recall that the ICJ did not invent new obligation, it clarified existing ones. These obligations arise from well-established principles of international law and build upon a rich landscape of climate jurisprudence. The opinion itself carries remarkable legitimacy, and we've heard about this. The request from the General Assembly for the ICJAO was adopted by consensus. The proceedings saw record participation, 109 states and international organizations. The opinion was delivered unanimously. The voices of Pacific states, young people, and the global majority shaped this process. What remains now is the political will to act on the court's ruling. And this is where the UNGA resolution becomes critical. General Assembly resolutions responding to advisory opinions do more than simply welcome them. They operationalize them. Leanne mentioned this. What is happening right now is well within the established parameters of how these resolutions take place in practice. Such resolutions help translate legal norms into political commitments and implementation pathways. We have seen this in previous advisory opinions, including those concerning Palestine and Chagos, where we see that these resolutions provided clear mechanisms and timelines for monitoring, accountability, and reparations in line with obligations and to ensure to operationalize the legal conclusions of the ICJ. Such resolutions have also provided powerful hooks for an iterative focus on implementation, for example, through mandated follow-up reports. Unlike resolutions in the past, this resolution also aims to harness the authority of the court, align state conduct with clarified obligations, and advance justice and accountability through collective and cooperative action. The court has clarified the law, and now the international community must decide whether it will act on it for the sake of the people today and for the generations yet to come. And one of the things Vishal had asked me when we were just speaking about this, and I'll wrap with this, is what is the one thing that kind of uplifts why the UNGA resolution is so important right now? It's very much about reaffirming faith in multilateralism and the rule of law. At a time when international law and its institutions are deliberately being undermined, this resolution process provides, at a global scale, a key opportunity to counter the growing trends of isolationism, and rejection of multilateral cooperation, offering the promise of how existing mechanisms and processes can be advanced to meaningfully address a crisis that threatens us all. So I'll leave it at this, Shiva. Back over to you.
Mr. Langjoy, for those insightful reflections and for helping us better understand how international law can advance climate justice and breaking down the most important legal clarifications for us. Building on that legal perspective, we now turn to the important human rights dimension of this conversation. It is my pleasure to introduce our next panelist, Professor Elisa Morgera, the United Nations Special Rapporteur on Human Rights and Climate Change. Professor Morgera is a leading voice at the intersection of environmental protection and human rights, and her work has been instrumental in highlighting how climate change affects fundamental rights, particularly for vulnerable communities across the world. Today, she will reflect on a critical question. What does the ICJ Advisory Opinion change politically? And why is this a moment of courage for the international community? She will also speak to how this legal clarity can be translated into meaningful action through the UNGA resolution, ensuring it becomes a catalyst for real accountability. Please do join me in welcoming Professor Elisa. Elisa, the mic is yours.
Yeah, thank you so much. It's an honor to be in this panel. And once again, thanks to all of you for the leadership you have shown time and again over and in very difficult context to get into the world, to humanity and future generations, such an important advisory opinion. I think a lot has already been covered about how historically important this advisory opinion is, how distinctive, including how extensive it is in the legal clarifications that in the International Court of Justice, which has been traditionally a relatively conservative international tribunal in terms of international environmental law, but crucially how inclusive and uniquely participatory this process has been. And I think what's crucial in terms of the political relevance of the advisory opinion are perhaps two things. First, how the legal findings of the court are a reflection of the lived experiences of people in small island developing states and other most climate vulnerable countries, but also how the legal clarifications are a clear response to the demands of children and young people and other human rights holders who are most negatively impacted by climate change across the world. And yes, those legal findings are in perfect alignment with climate science, but crucially, they're also in line with other areas of sciences, with health science, showing us that fossil fuels are not only the main cause of climate change, but they're also the main cause of the other planetary crises we're facing, toxic pollution, including in the form of plastic pollution and the pollution coming from petrochemicals in our food systems, and the loss of nature. And it's important to consider that all these negative impacts on different dimensions of the environment and different dimensions of our human right to a healthy environment, they all in and of themselves make the climate crisis worse and undermine the capacity of nature and our human capacity to be resilient in the context of the worsening climate crisis. I think what's also important politically is that what the International Court is saying in all those legal clarifications that have been just explained to us is that the predominant interpretation of the Paris Agreement and the international climate change regime as a whole, which has really been the interpretation of the countries who are most responsible for climate change, is not accurate, it's not legally tenable, and we should move away from the implication of that predominant interpretation across all multilateral fora, and very much so in the context of the climate COP. That prevailing interpretation was an interpretation of considering the international climate change regime as the only relevant and applicable area of international law to international cooperation on climate change. One, as we've heard, that mainly foresaw voluntary action as opposed to legally binding obligations for states. And they did not really see the climate, despite the wording of all the relevant climate treaties, as part and parcel of all the interconnected life-supporting systems of our planet. And so the clarification that climate action must be also biodiversity action, protection against land degradation, protection against also toxic pollution, and crucially, human rights action. That I think is not surprising to many of us. It definitely aligns with our best available science and with our lived experiences, and yet it's something that has not yet had currency, and it's not reflected in either climate action at the national or international level, and certainly is also not reflected in the objectives of international financial cooperation, for instance. So what that means is that the advisory opinion should really lead to a culture shift in international climate negotiations, but also in any other international fora that are meaningful for climate action. And again, the ICJ clarified that this can be many other areas of the UN system where we are discussing protection of nature, where we're discussing protection of the ocean, where we may be discussing plastics or protection of health or toxic pollution. And crucially, any decision, unilateral, bilateral, or even multilateral, they may have to do with fossil fuels. Because again, what politically the advisory opinion means is that fossil fuels can no longer be considered like any other natural resource. They are the main cause of climate change, and they may be considered in the extraction, expansion, consumption, and subsidies as internationally wrongful. So what we have not seen, however, despite this paradigm shift in political and legal terms of the advisory opinion, is at least the beginning of a change in the understanding of legal obligations and the content and priorities for international cooperation in the context of the climate COP. COP30 not only did not reference the ICJ advisory opinion, but there were proposals to retrogress really on the legal clarifications as well as the science. And ultimately, it was not even possible to mention fossil fuels in any of the outcomes of the COP, notwithstanding the demands from children and youth, from a significant number of states, from the medical community, and from multiple international human rights bodies who have also come to that conclusion of the human rights imperative of phasing out fossil fuels. So then how should governments translate this advisory opinion in international cooperation that is meaningful? We need to see, first of all, a clear endorsement of the importance of multilateral action in operationalizing those legal clarifications and moving towards a change in the diplomatic culture, as well as the bilateral and multilateral cooperation related to climate change that is aligned with the comprehensive and holistic interpretation of the International Court of Justice across all UN bodies and across all relevant international fora, and where we know that this fora may not be working or may have been misused, including in terms of bad faith engagement in the context of consensus making, states have an obligation to create other multilateral processes where it is possible to take meaningful action within meaningful timelines that can prevent further climate harm and prevent foreseeable human rights obligations. And we're seeing this, for instance, in the initiative taken by Colombia and the Netherlands in organizing a conference in Santa Marta at the end of April to advance with states who are willing and participation by civil society, academia, subnational governments, and many others to develop meaningful approaches for that phase out of fossil fuels. But I think it's also important to think where it may be more difficult to move forward, and yet we need to do so. There are two key aspects that I think would make that international collaboration meaningful and not symbolic. First of all, recognizing where existing multilateral processes are not working in line with international law, in line with science, in line with the legitimate demands of human rights holders who are most affected by climate change and by climate inaction and obstruction. And so recognizing that, for instance, in the context of the climate COP, we need very significant reforms of procedures, of consideration of relevant science, of inclusiveness of processes and knowledge holders that will allow state parties to take into account all the areas of law and science that the ICJ has identified as being relevant and applicable in the context of meaningful climate action. But crucially, the second point is that, and I'm thinking particularly for the areas of the advisory opinion that we know are more politically charged, and that is the case of reparation, that's the case of loss and damage. We need to have the difficult conversation, and we need to have a difficult conversation that is constructive and where every state can learn from one another. And I think this is so crucial, both because we have, in some cases, like in the case of Vanuatu, which I had the privilege of visiting during the oral hearings of the ICJ, we have 10 years of compounding human rights impacts, devastating impacts of climate change. And many other countries find themselves in the same situation or similar situations across the South Pacific, in the Caribbean, in Africa, in Latin America, and in Asia. But also, many citizens across the world are now facing devastating climate impacts and are willing and demanding to learn, to understand what can be done and what we've learned in terms of responding to what was unforeseeable and remains very challenging, but for which now we have lived experiences, understanding, and the more we understand around what is being lost and what is being damaged, the more we can all prepare in meaningful ways, we can all, to the highest possible ambition that every state is capable of, prevent effectively further climate harm, further environmental harm, and further human rights violations. And so I would encourage every state not only to recognize the historical importance of the advisory opinion, the truly paradigm shifting nature of the legal obligations, but also the necessity for every single state in our planet that they stand to benefit from implementing this advisory opinion and really finding the most meaningful ways for mutual learning and supporting processes where reparations in all their forms, many of which are actually a reflection of their pre-existing primary international obligations, how all of that is to ensure the protection of everyone's human right to a healthy environment, everyone's human rights to a healthy, a safe climate, and particularly children's human rights to a healthy climate. Thank you.
After lastly, Professor Elisa, for those powerful insights about why the AO is important across all UN and international fora, but also thinking about the practicalities of where it will work and where it won't. Your reflections remind us that climate crisis is not only about environmental challenges, it has profound human rights impacts across the world. For the audience, please do not forget to add your questions to the chat. As we move to close our panel, it is my honor to introduce our final speaker, Mr. Vishal Prasad, the Director of Pacific Island Students Fighting Climate Change. Vishal has been a driving force behind the youth-led campaign that helped bring the International Court of Justice Advisory Opinion to life. His leadership reflects the determination of young people across the Pacific who have transformed their lived experiences of climate change into global advocacy for justice and accountability. Today, he will share his perspective on how this moment can serve as a catalyst for deeper engagement, particularly among youth and frontline communities, as we work to translate the legal milestone into real action. Please join me in warmly welcoming our final speaker for the session, Vishal.
Thanks, Shiva. Bola Vinaka, everyone. Thank you so much for joining us today. And also a big thanks to all of the panelists who've spoken so clearly about the ICJ Advisory Opinion and the upcoming UN General Assembly resolution. And I think it's a very timely conversation and one that's desperately needed. And in so many ways, we find ourselves currently in a more complex, in a more challenging world than we did yesterday, for example. And so I wanted to begin from a very simple place. A few years back, I was part of a team that traveled to some of the most remote parts of Fiji to collect testimonies and evidence for the ICJ proceedings. And while doing that work, we heard some of the most heart-wrenching stories of what it means to live with the impacts of climate change, day in and day out. And if you read some of the annexes to the submissions made by many Pacific Island countries, you will see what I mean. You'll see in those testimonies the pain of villages who have been severed from their ancestral land, standing with questions. You will hear about cultural rituals and practices that are almost gone, and they're gone just like the harvest that once filled village grounds every harvest season. These were aptly put by our dear friend Julian Agon in his oral pleading before the ICJ when he said, they have lost nearly everything that has, since time immemorial, formed their very essence as peoples. And a little over 6 months, the ICJ heard the call from these communities, and in its unanimous ruling affirmed that states have obligations under international law in relation to climate change. That matters because these communities on the front lines have always known that the crisis that they face is not just unfortunate, it is unjust as well. And it is not only about emissions in the abstract, it's also about responsibility. It's about harm, it's about the rights that are being affected, and it's about whether international law can actually mean something for people whose lives are already being shaped by this crisis. But legal clarity alone does not protect a single village from the rising seas. It does not rebuild homes after cyclones. It does not restore what has already been lost. And it does not automatically change the behavior of the states most responsible for this crisis. That is why this resolution matters, and why the work of operationalizing the advisory opinion is so important. This resolution, as has been mentioned, is a bridge between what the law has made clear and what the international community now chooses to do with that clarity. If states have obligations, those obligations must be implemented. If rights are being harmed, those harms must be addressed. And if future generations are being put at risk, institutions must act with urgency now. And I think from civil society's perspective, that is the key question in this moment. But now that the world's highest court has spoken, what will states do next? And thankfully, this resolution provides that opportunity for states to act, but also helps answer this question. Why does the advisory opinion resolution, why does this resolution matter? First, it matters because the resolution helps prevent the advisory opinion from being treated as symbolic. We've seen that there's always the risk that after a landmark legal development that states welcome it politely, praise it publicly, and then continue with business as usual. And we think a strong UNG resolution can help ensure that that does not happen. It can send a clear message that the opinion is not just an abstract statement, it is guidance for action across the UN system and for states themselves. Second, this resolution matters because it creates political momentum and institutional follow-up. Strong change can happen when legal developments, diplomatic processes, and public mobilization reinforce one another, or they come together. The ICJ Advisory Opinion provides the legal grounding. This General Assembly resolution can provide the political vehicle for action, and public engagement can provide the force that keeps both of this moving. And if done well, this resolution can help embed the opinion into the work of UN bodies, into national discussions, and into future climate policy. And thirdly, this resolution matters because it creates space for those most affected to shape what comes next. Civil society has always played a crucial role in climate justice movements, documenting harms, advancing legal arguments, and shifting public narratives, mobilizing across borders, and insisting that international law must serve people, not just power. And this process is not only about states talking to states, it is also about whether communities, especially those on the front lines, can see their realities reflected in global action. Now, with the opinion in hand, we know the path ahead is not going to be easy. We know this all too well, that progress does not happen simply because the truth has been spoken. Progress happens when people organize around the truth and refuse to let it be ignored. And by taking one step at a time, we all here have a role to play in moving the story of the ICJ Advisory Opinion campaign forward. Supporting this resolution is not just a job for diplomats in New York only, it is a job for all of us. And so I wanted to discuss some practical steps on how we can all support this process, but also support broadly the operationalizing of the advisory opinion. First, we need to engage directly with our governments. Everyone attending here today can ask whether our governments are going to support this resolution, whether they're going to co-sponsor the resolution. Will it support a strong final text, and what's their position in consultations? We need to be asking our leaders, our governments, this is a very important question. We can write letters, request meetings, issue public statements, brief diplomats, or even work with our regional and national allies to help build momentum towards the vote. There are many resources that are available that can help support this. We have an advocacy pack that's been prepared, template letters, key messages, social media packs that can all be utilized for help. And we're also organizing big tent mobilization calls next week on this to allow everyone that's interested a space to connect and to join the work. And we would extend a warm welcome to everyone interested here. The second thing that we need to organize for ambition, because not just any resolution will do. A weak resolution that empties the advisory opinion of its force is not enough. We need one that centers human rights, one that centers intergenerational equity, accountability, and the realities of those already facing immense loss and damage. And finally, we must stay engaged even after adoption. I think adoption will not, and very, very rightly said by everyone before me, adoption will not be the finish line, but we will need to monitor implementation. We will need to keep pressing institutions, keep pressing governments to act with ambition and accountability, and to use the advisory opinion and the resolution together as tools for advocacy, education, litigation, movement building, and accountability. This is the next step in the ICJ Advisory Opinion journey. The ICJ has provided the blueprint. Now it's time for the world to build using it. Thank you so much.
Parapa Vishal, for that wonderful contribution. Your remarks always reminds us of the strength, the courage, and determination of our youth leadership in advancing the movement for climate justice, but also how this AO can play a role to bring accountability and justice to those who face this climate injustice as a daily reality. Thank you for all the steps you have highlighted that people can get involved in, and a huge amount of respect always to the Pacific Island students fighting climate change for the leadership and vision to unite the world, but also to change the world for a better future. With that, I would like to extend my sincere gratitude to all of our panelists for sharing their insights, their time, and expertise with us today. Your perspectives have helped deepen our understanding of how this historic moment can move from legal recognition towards meaningful global action. We will now move on to the question and answer portion of this session to continue this conversation. So maybe I'll just start off with the first question to Professor Eliza. The question is that in the case where a register of climate damages will not be accepted via the UN resolution mechanisms or platforms, what other substantive processes are there to ensure such a register will enable effective operationalization of the advisory opinion?
Yeah, I mean, I think we can use many existing multilateral processes to advance understanding of loss and damage. I mean, we could do that in the context of the Convention on Biological Diversity, the Convention on Desertification. In fact, we'll have their COPs happening this year. And of course, also in the context of the existing processes under the international climate regime, as long as we see that shift in interpretation and practices that is aligned with the interpretation that has been provided by the International Court of Justice. We are doing that also in several processes under the Human Rights Council in Geneva. For instance, there's a process now to develop a report on the human rights impacts on sea level rise. These are always processes that are participatory to different extents, and different experts and human rights holders can provide their own understanding of loss and damage, and also what should be the responses. So I think we can utilize every single international fora that, as the ICJ has clarified, is relevant for climate action to advance that understanding of loss and damage. And in fact, it may be very helpful to have different perspectives and different expertise across these bodies of international law and practice to offer complementary insights into this that haven't yet been fully considered in the context of the international climate regime.
Thank you, Elisa, for that. I will move on to the second question. This is for Leanne. It's a long one. It's got multiple parts to it, so hopefully you can answer all of those. Does the current draft of the resolution include explicit language on fossil fuels? And if so, whether that would likely appear in the operative paragraphs rather than just the preambular section? And then the next question is, how is the resolution expected to advance the conversation on reparations or loss and damage beyond simply what was, sorry, just give me one sec. I think it's beyond what was stated in the advisory opinion. For example, are there ideas about mechanisms or processes that could help operationalize state responsibility?
Thank you very much for the question. Before I respond to the question, I'll just add on to very quickly to Elisa's response. I think all of those areas are fantastic areas to explore and are very equally as important as the areas that are being explored under the UNGA resolution. But just one thing I'd like to point out is that under all of those conventions, it depends their enforcement or the accountability that can be sought through them is really dependent on who the state parties are to those treaties, unless they have the status of some of the articles have the status of customary international law. And one of the things that the UNGA resolution really adds value to in relation to state responsibility is its reach to every single state under the United Nations, particularly for those areas of customary international law that entail obligations, erga omnes. And so it'd be great to see those areas being progressed as well, but definitely not as an alternative for the current resolution before us, I think is the point that I'm trying to make there. I'll come to the question now on what is in the resolution itself. Yes, there's explicit language on fossil fuel. And initially we hoped for fossil fuel phase out, but as you can imagine, that is particularly sensitive. And the language around that is currently being, is subject to ongoing negotiations. And so there have been other proposals around a fossil fuel transition away from fossil fuels in line with the COP28 UAE consensus GST language that may be a middle ground or a landing zone for many states, but we'll see if we can get it through. Again, for this resolution to be successful, we need to have broad support, and what broad support looks like is not a simple majority of states supporting the resolution. We've seen in previous resolutions, especially more recent ones on the advisory opinions, around 130 states, and in other resolutions that are accepted as being broadly supported, having around 150 states voting in favor of it. And if we look at the requesting resolution from 23, that was co-sponsored by 132 states. So looking for similar numbers like this, because anything less has the risk of, I guess, reducing the status and the strength of the advisory opinion itself and its acceptance. And so it's really a matter of trying to find that balance between that full and unequivocal welcome of the advisory opinion as the bare minimum and the more ambitious areas that progress climate justice and stronger climate action in the resolution itself. And so as we go through the negotiation process, it really becomes a little bit of what I've described many times as a numbers game, as we assess which elements in the resolution get those numbers and which ones don't. And then from there, try to find the language that works to essentially meet those numbers. There's also, this resolution, we've got elements in there requesting that it come back to the UNGA annually to report on implementation of the resolution. And this is a really critical element because subsequent resolutions or subsequent decisions on the resolution can still be passed by majority. And while this particular resolution requires a substantial, broad support majority, if not everything is in the in the resolution that we hope for this time round, these subsequent resolutions provide a door for us to continue progressing this, hopefully when the global political climate shifts to a better place for climate justice. So there is fossil fuel language, advancing, how does it advance reparations and mechanisms and processes? So I did mention this earlier on, but perhaps not in a lot of detail. There are elements in the resolution. I mentioned earlier we were first calling for the establishment of a register for climate damages, and an accompanying mechanism for climate reparations. But this is proving to be a real challenge and one of those areas that we are really concerned that might risk the full and unequivocal welcome of the advisory opinion itself, and may not gain the numbers that from what we've received in negotiations so far, we know that it won't receive the numbers that we hope for. In any case, it's being perceived as a slightly new concept that hasn't had the opportunity or the time to be really socialized extensively to get that broad support, but there is definitely that potential there given time. In fact, though, it's not such a new idea, even though it is being perceived this way. There are existing mechanisms. There are registries that have been for harm that have been established under previous ICJ Advisory Opinion resolutions adopted by the UN General Assembly. In fact, one of the registers at the moment is hosted by the Council of Europe and has been fully accepted there. There are some concerns that, a register for climate damages is difficult, and the other registers are in very different contexts where the causal link is far easier to establish. But as we know from the advisory opinion, even though it's difficult, it's not impossible. And as attribution science progresses, there's more and more opportunities to strengthen those linkages there, and better refine what the potential is there, which is part of what was in the request for the secretary, the report for a Secretary General to explore a little bit more. And I'll come to that in just a moment, the SG's report. Before I got there, I just wanted to suggest that, just a moment while I just check my notes again. So in addition to the registers not being new ideas, because there's precedent for this in the UNGA, reparations are also not a new idea and have extended beyond, or are being extended beyond, conflict situations. So at the moment, I understand that a UNGA resolution is being progressed on reparations for slavery by members of the African group. And so again, there is already movement towards better recognition of state responsibility and bringing that alive in multiple different contexts. And so again, the argument is, why should climate change be excluded? Similar to the arguments that we made before the court, why should climate change be excluded from general principles of international law and international law more broadly, right? And in addition to that, these mechanisms, or the register and the mechanism, was not even an original idea from Vanuatu. We've seen this referred to many times in reports for many years from the special rapporteurs, making recommendations that these mechanisms need to be established to address some of the gaps in the current climate regime to support efforts, loss and damage, or climate harm efforts. So it's a little bit tricky with the terminology between loss and damage and climate harm, because loss and damage is very much language used under the climate regime, where climate harm is very much linked to state responsibility. And so at the moment, there's a big gap in state responsibility being addressed under, in fact, I know AOSIS at one point in time was trying to progress state responsibility being included in how loss and damage is addressed under the UNFCCC, but we're told, no, state responsibility, this is not the forum for state responsibility. And this is something that has come up in negotiations, a reminder of this, because now we bring it back to the UNGA, and there are many states that are saying, no, this isn't the forum for state responsibility. We need to bring it into the UNFCCC. So it's just the ball that's being passed around at the moment, not really finding a home, because it's not so palatable for all states, essentially, or convenient for all states. So with that very long background explanation, sorry, I'll stop talking soon. I really get into this, as you can see. And the way that the negotiations have been going, what we are focusing on now to try to ensure that the climate justice elements, or some aspect of the climate justice elements, are retained, but with some significant concessions to try to build that broad consensus, is a process-focused approach where we request the Secretary General to make a report that looks at options and proposals on the idea of establishing a register, and also takes into account how it can consider coordination, coherence, and complementarity with the existing mechanisms, because this is a criticism that we're hearing, or a concern that we're hearing a lot, concerns around not creating duplicate or parallel processes. The existing climate regime already works, so why are you trying to replace and take us away from that? That's absolutely not the intention at all. The climate regime is fantastic. We've made such great progress there, but we also have international law now to strengthen it. And if international law can't be applied in its full entirety under the climate regime, then we also need to think about other forums where it can be progressed. And as I mentioned right at the very beginning, the UNGA has the broadest, what's the right word for this, mandate to be able to address this effectively across all of international law, including customary international law. Thank you. I'll stop there now.
Thank you, Leanne, for explaining all the complexities, I guess, of diplomacy, even when the highest court has kind of given this ruling. We've got a lot of questions, and we've got about 7 minutes. So we'll try and maybe we'll go over by 5 minutes or so if people wanted to stay. Next question is for Joey. Joey, what do you think about the International Court of Justice's dismissal of the polluter pays principle as not being part of customary international law? Is such a finding consistent with the application of state responsibility?
Thanks, Shiva. And I'll keep it short given that how many questions there are. But I feel like the court did say that the polluter pays principle is not part of the applicable law in relation to this specific AO, but it did clarify that is because in its reading, the polluter pays principle does not apply directly to state relationships, which is actually, if you take a very narrow view of the polluter pays principle, is quite accurate because it is national with usually with private entities. And the court was very clear. It also did not close the door on the principle. It does keep the door open, especially in terms of strict liability articulations. But of course, the court could have more robustly engaged with it. And Justice Bhandari goes into this in his separate opinion, where he really talks about the fact that this was a pretty narrow approach and really had wished that the court had gone deeper into a kind of more deep, like a more robust articulation of how the polluter pays principle can be viewed more broadly and as anchored in kind of broader environmental legal jurisprudence. So I think the reading of how the court deals with the polluter pays principle has to be nuanced in that way. On the other hand, I think that it doesn't affect how the law of state responsibility applies. That is very clear from the court, that if there is climate harm and that harm can be attributed to a state, the law of state responsibility applies in full. So that does not affect, in that sense, the application of the law in relation to climate. So I think I'll stop there, Shiva.
Vinaka, Joey, for giving you insights around that. Next question is for Vishal. Do you have any specific hopes for COP31? And can this bring meaningful attention to the Pacific?
Yeah, thanks for that question. Very briefly, I think Just alluding to my earlier point around this shifting focus to operationalizing the advisory opinion, I think we need to be doing that across as many platforms. And the UNGA is one very important platform we're talking about, but we need to keep doing this work of introducing and bringing the advisory opinion into as many spaces, into as many platforms that need to now align with what the law has said. And so COP31 does provide that opportunity, and as civil society, we want to ensure we show up in a strong manner, so that the findings of the court, backed by the UNGA, become very difficult to ignore for spaces like COP, and that it's reflected in that manner. And I think that's something we're looking forward to doing as we go into. So a lot of hope for COP31 in terms of featuring and bringing and spotlighting the advisory opinion into whatever decisions, whatever outcomes are made at COP31.
Thank you, Vishal. The next question is for Professor Eliza, the round robin of people answering. Is the forthcoming UNGA resolution on ICJAO binding or not binding? What are the advantages or disadvantages of binding or not binding for climate actions and climate action and climate justice? Maybe the first, if we can answer just the first part, which is it binding or not binding?
I mean, UN General Assembly resolutions are normally formally non-binding, but I think the question is really that doesn't matter so much in this context, because you have an advisory opinion that clarifies a plethora of international legally binding obligations on states, including customary law obligations binding on all states. And that remains. So the UN General Assembly resolutions will be supporting and complementing the process in terms of the operationalization, but the legally binding nature of a much wider set of areas of international law has now been confirmed unequivocally.
Thank you, Professor. Leanne, the next question is for you. Again, multiple parts to it, but maybe if we can keep this one to, I'll cut it out to about 2 parts. Do you know if Australia is supporting the UNGA resolution? And what is the timeline ahead of us regarding the draft resolution? And when would it be submitted and then voted?
Great question. So Australia have been engaging constructively and very supportively to date. And so that's been very welcome from our perspective. And we look forward to this continued constructive engagement with them as the future COP leadership. It's a critical role for them to play, and we see this as an opportunity to really strengthen the linkages between this resolution and the COP and the broader climate regime to, I suppose, in a way, reiterate that it's not a competing agenda here. It's one and the same. For the timelines, they shift quite regularly, I have to say, because of the level of engagement, which always surprises us. The informals have been participated in what I would estimate between 70 and 80% of the states. Even in the most recent round of informals, we had input received from 106 states in total. So it takes time to process everything. And states also want to make sure that they have adequate time to be able to review the draft and prepare their input. So the revised draft will be released tomorrow, and the next round of informal negotiations will start late next week and go into the week afterwards. And then from there, we'll need to assess where the positioning is. The latest revised date, it was initially the 30th of March that we were aiming to have the resolution adopted, but there is a specific amount of time between that the resolution needs to be uploaded to the e-delegate site for before it can actually be adopted. I think it's around 2 weeks, and so it means we're not going to meet those timelines at the moment. And so, long story short, the new date that we are proposing is the 22nd of April for the adoption of the resolution, which happens to be Earth Day. And so, fingers crossed, we make it to that date this time. Thanks.
Thank you so much. Thank you so much for clarifying also the timelines. Might take a couple more questions and then I'll have to end this because that's the worst job of a facilitator in this, to try to keep to time. Joey, this question is for you. I wanted to ask about the reparations mechanism sought by Vanuatu. Is there a blueprint for what this might look like, or what reparation might be sought?
Well, Leanne is there from Vanuatu, so I don't want to speak to that, but I can speak generally, and then maybe Leanne, you could come in. I think there is the court gives guidance, pretty deep guidance on the forms of reparation that might be there, whether that's restitution, where it talks about rebuilding infrastructure, recognizing the difficulties of it, or ecosystem restoration. It talks about compensation. It talks about satisfaction, apologies, acknowledgements, but also in forms of reparations that would be needed. If we go back to the proceedings, the submissions from states, their oral arguments, there was such brilliant arguments in relation to the forms of redress that would fit specific contexts, whether that's SIDS or whether that's in desert contexts or whether that's in like specific regions. Debt cancellation, for example, came out so strongly. So I think there is a lot of grounding for figuring out how to formulate such a reparations mechanism and what forms of redress it could provide. And then, as Leanne mentioned, there is precedence. There is actually international reparations mechanisms that have been proposed by previous UNGA resolutions, in multiple ones. I think one's connected to Palestine, and then there's the new one coming up as well. If you look through transitional justice, there's blueprints that we have. So absolutely, I think they're there. So if there is political will to move on this, I think the blueprints would be available. But Leanne, if specifically you wanted to come in on the Vanuatu perspective.
Yeah, thank you. I'll do so really quickly. So our concept of the register was to, well, at least our concept, it's not going to be only our concept now because of the process that will likely come out of the resolution having an SG's report where all membership has an opportunity to propose how they'd like the register to look. But the claims that we conceptually thought of were both economic and non-economic loss. And if you think about the legal consequences, the real, at its core, the legal consequences and the rules of state responsibility are there to try to put those harmed back into the position they were in before the harm occurred, right? And so we've got various legal consequences, not just reparations, but cessation, the reparations, satisfaction, that all connect, that can all be part of fulfilling those claims, but also link to some of the primary obligations that already exist under not just the climate treaties, but some of the other treaties. And in fact, I think Elisa and I were speaking about this more recently, and maybe you'd like to add on to this because I think you described it in a way, far more articulate than what I am now. But yes, this is what we're conceiving in the idea of the register and the accompanying mechanism. Elisa, can I hand over to you to share your thoughts on that?
Thanks. No, and I think that was very clear, but I'm happy to expand on that. I think, and this is something I have also elaborated in my report to the Human Rights Council last year when I was purely on the basis of international human rights law, looking at particularly the obligation of states to defossilize our economies. But of course, those reparations in the form of cessation of unlawful activities and guarantees of non-repetition, that speaks very much to that urgent phase out of fossil fuels, which again is a matter of primary obligations under international climate law, but also international biodiversity law and the protection of human rights. Joy just recalled that one of the forms of restitution is ecosystem restoration, which again is a pre-existing primary obligation under the Convention on Biological Diversity, and crucially, the International Tribunal for the Law of the Sea, in its advisory opinion, stressed how conservation and restoration of marine biodiversity is a primary obligation to protect the marine environment, and in fact contributes both to climate change mitigation and adaptation. I think other forms of reparations really overlap to a really significant extent with the existing international obligations of states. And I think maybe the tricky area is around compensation. And to me, there's again a critical question there about primary obligations. All the International Tribunal Advisory Opinion have confirmed that states have binding obligations to provide finance to developing states in the context of themselves being able to pursue their highest level of ambition in taking climate action and protecting from further climate harm and human rights. And we know that current climate finance is not sufficient either to support adaptation or responses to loss and damage. And often climate finance is also not directed in the right direction in terms of effective mitigation. So in a way, the question to me is that the layer of compensation here is first making sure that we have proportionate climate finance that responds to the magnitude of the harm and risks of harm that are now very much foreseeable for human rights and for the climate system, but also crucially that are co-developed with the human rights holders who are most affected by climate change. And this is again something that we're not seeing at play in the current mechanisms of climate finance and other forms of international finance that are relevant for climate action. Often the shots are called by donor states, who are the states who have most contributed to climate change, and there are no meaningful opportunities for the countries who are most affected by climate change and least responsible for it, and for the communities who are most affected by climate change to really have a meaningful voice that shapes the priorities and modalities of that climate finance. And this is the game-changing point, that we need finance that really responds to the gravity and the understanding of the loss and damage, and what would be meaningful responses that can protect all the human rights that are being negatively impacted.
Thank you, Eliza. And thank you, Leanne, as well, for all of those things. Thank you so much to all our incredible panelists for your powerful insights, your dedication, and your commitment to climate justice. I'm so sorry, guys. We do not have any more time for further questions. However, we will aim to answer your questions via email that you registered, and hopefully we can return back with all the answers to all the other questions you have asked. And to everyone who has joined today from around the world, thank you for being part of this very important conversation. As we wrap, here are a few key takeaways from today's session. I'll try to rush this through. The obligations are owed to the whole world. The highest court in the world made it very clear to adopt and enforce policy and legal measures to address climate harm. Fossil fuel production, consumption, exports, subsidies has been put on notice, and this may constitute an internationally wrongful act. This advisory opinion is about past, about present, and future, both in terms of those causing climate harm and those who will inherit this world as their home. The importance of multilateralism and keeping that powerfully active and alive is more important than ever in the current environment. Legal findings are built upon and aligned with best available science. We need to see beyond the Paris Agreement when addressing climate injustice. Advisory opinion should lead to a cultural shift in international negotiations and any other international fora to protect human rights. We need to have the difficult conversations about reparations. The legal clarity does not bring back the things that are already lost and damaged, and that is why this advisory opinion is extremely important. It is to hold those who have caused this accountable. We need to engage directly with our governments, write letters, brief diplomats, write emails. And there's many resources that has been created, so please do reach out to us. We need this advisory opinion not to be weak. We need to ensure that it addresses the realities and the human rights impacts of the most climate impacted. And this advisory opinion needs to be in many platforms and in many spaces. So with that, much love and respect to all of you. Additional love in these current times. Stay safe and keep all those who are going through the immense tragedies of injustice in your love and hearts. And thank you for your fight for climate justice always. So tatale mo demanda.